Good morning, class. Today I want us to talk about criminal law and tort law. In the beginning, we classified law into private law and public law. So as we begin with criminal law, this is under public law. And if we look at what we define crime to be, crime is an offense. And so we are saying, when we are saying someone has committed a crime, it means this offense has been committed against the state. So therefore, criminal law deals with offenses against the state. And as we proceed, I wish that we define the term claimant. Who is the person who has suffered injury? This person is also called a plaintiff. A defendant is an individual, company, or institution. Remember, company or institutions are artificial individuals, accused or sued in a court of law. So presumably, this is the person who is said to have caused the plaintiff or the claimant harm, yet to be proven in the court of law. There are certain features that must exist for us to say crime has been committed. Offense is committed against the state. For example, breaking traffic rules is an offense against the state. Robbery, assault are offenses against the state. The aim of criminal law is to punish and deter from further similar actions. For example, a robber who is charged in court and found to be guilty is punished by imprisonment so that they can suffer pain, and that experience will deter them from committing future similar actions. For crime to exist, there must have been intention. The person committing the crime must have intended, if it's a thief, must have been intended to steal and actually have stolen, and that's what we call execution of the unlawful act. Crimes are enforced by the state, and therefore a criminal case is usually initiated by the state, and that is what we know is the police. We have types of crime, very many. I've just listed a few here. We have robbery, burglary, rape, violence against women or children, what sometimes we call domestic abuse, theft, arson, homicide, child abuse, kidnapping, assault and battery. In short, these are crimes that assist others, like aiding, conspiracy, aiding the enemy, conspiracy, and so on. Drug trafficking, driving. While breaking the traffic rules, we have driving without license, driving under influence of alcohol, and other traffic rules, like even driving without insurance cover, counterfeiting, cheating, sexual harassment, buying or selling of gas for prostitution. These are some of the crimes, but not all of them. We have elements of a criminal offense. An element is what we really have to prove to justify that this is a criminal act. We have actus reus, mens rea, concurrens, harm, corpus delicti. Actus reus is referred to as the guilty act. It is the unlawful act committed that comprises of the physical components. The wrongful act that makes up the physical action of the crime. Yeah. I've given a small example here. If somebody steals your cow, then this is actus reus. You can say, my cow has been stolen. Not that somebody is intending to steal my cow, but it is my cow has been stolen. For example, also, if somebody steals your bag, your laptop, your phone has been stolen. So that is actus reus. There is the physical component. The guilty act has been committed. Then let's look at mens rea. Mens rea is referred to as the guilty mind, which proves the intention. There was a criminal intention to commit the unlawful act. It's a state of mind required in order to convict a particular defendant of a particular crime. The person who stole your phone, your laptop or whatever, must have intended actually to steal from you. Levels of mens rea include purposeful, knowing, or reckless. Let's look at concurrence. It's the merging of the actus reus and mens rea, the criminal act and the intention. They must concur. There are physical items stolen and there was also intention to steal. Then let's look at causation. There must be proof that the criminal act is the actual cause of the harm suffered by the claimant. So, it must be shown that the harm is because the criminal act was committed. We have categories of causation. There is the factual cause. It must be shown that if not for the actor's conduct, the harm would not have occurred. And then there is the legal cause. Consequences of an act which are not reasonably foreseeable to the actor, but legally they have been caused. Then lastly, there is harm. It has to be established that injury has occurred to another or to the society. I've always given this example whereby, Kenya Power contracts somebody to bring in transformers, and the somebody brings in fake transformers or substandard transformers, which is then installed to community B. Community B suffers lack of electricity, which they are paid for, due to, substandard transformers supplied by person A. So in this case, injury has occurred to the society. And then that is harm. So once a criminal act has been submitted to court and you are the defendant, what defenses are available to you? So let's look at defenses to criminal liability. A defense refers to a method of defending or protecting. It is a response by the defendant which allows them to avoid criminal liability. So, defenses in a criminal suit include alibi. It refers to the theory that someone cannot be guilty of a crime when they were somewhere else when and where a crime occurred. That is, the defendant was not at the crime scene when the crime occurred. We've seen so many murder cases which were being proven to be caused by person A. And person A says, at the time of the murder, I was out of the country, I was attending a meeting, which can be proven, and so on. So, this basically may mean that how can I be responsible when I was not at the venue where the crime occurred? The second one is affirmative defense. So in this case, the defendant admits that they committed the act but deny criminal liability. In this defense, the defendant introduces evidence which, if found to be credible, will negate criminal liability or civil liability, even if it is proven that the defendant committed the alleged act. Yeah. So, if for example, person A is served a substandard good and they return the good to the shop where they bought it, and the shopkeeper refuses to give them a replacement. And they take good B in exchange of good A. And in the process, goes away with good B. And the owner of the shop decides to accuse them of theft of the good B. And the matter goes to court. They can say, I took this item in exchange of a substandard good that they had, and if they give me the substandard good, then I'll be able to return what is in my possession. The third defense is justification defenses. A defense in which the defendant admits they are responsible for the act, but claims that under the circumstances, the act was not criminal. For it was used for self-defense, or they were executing a public duty. For example, where people, like in the attack in the Westgate, we found civilians using their guns on the criminals, and they were using it to defend themselves and also to defend other people who never had firearms. Also, this has happened between individuals exchanging, where one person has been pushed to use their guns for their own defense. When the Kenya power people come to a compound, they always go to their meter, and you cannot accuse them of destruction of property since they were executing public duty. So in this case, a defendant who committed the crime as defined claims they did no wrong because committing the crime advanced some social interest or vindicated a right of such importance that it would outweigh the wrongfulness of the crime. So on criminal law, I want to give you an assignment. Read and make notes about the criminal procedure in Kenya. And that brings me to the end. We have the law of tort. Tort is a branch of private law. As I told you, we have public law and criminal law. We have actually covered criminal law under public law. So, in private law, we have the law of torts, we have the law of succession, we have the law of contract, we have the insurance law, hire purchase, cooperatives. All these are under private law. A tort is a civil wrong committed against an individual. Liability in tort comes from either a breach of duty owned by members of society towards each other or the infringement of a right of another person. The aim of the law of tort is to protect the rights and freedoms of individuals, their property and reputation. How does tort differ from crime? In criminal law, we say that one of the greatest elements is that it is started by the state. So such a case will be started by the police. In tort, the case is started by the affected individual, usually from the individual's lawyer. Defendant will be persecuted in the criminal courts, while on tort, defendant will be sued in civil courts. The defendant faces criminal charges and a civil action will be brought against the defendant in tort. In crime, the main aim is to maintain law and order and to protect the public. In tort, the main aim is to provide the individual who has suffered from infringement of a right or duty with a remedy to enforce their rights. Crime is a breach of public law, while tort is a breach of private law. Crime requires standard of proof beyond reasonable doubt, while in tort, standard of proof is the balance of probabilities. In crime, the criminal action must have been intentional, while in tort, proof of intent is not required. In crime, the burden of proof lies with the prosecution, while in tort, burden of proof rests on the claimant. And in the crime, the aim is to punish, and in tort, the aim is to compensate. Types of torts. We have negligence, defamation, trespass, and nuisance as major types of torts. I want us to begin with the tort of negligence. So, what is negligence? I would say it refers to a breach of duty of care or the failure of one party to exercise the standard of care required by law, resulting in damage to the party to whom the duty was owed. So, what is a fault? It's an act or omission committed by the defendant which causes the claimant damages. And just as in crime and we talked about claimant and defendant, where we say that the claimant is the person who suffers harm, or also called the plaintiff. The plaintiff is the claimant. So, a defendant is the person accused of the act. We have another term, danum sine injuria, which means loss or damage in terms of money, property, or any physical loss that occurs without the infringement of any legal right. It is not actionable in law even if the act was intentional and done with the intent of causing harm to someone else, but without infringing on the person's legal rights. Yeah, a case I would give you an example is in business where people lose clients to other people. If you lose a client to a business person B, and they get the sales and you don't get the sales, which results in, lower sales or results in your business even closing, the person B has caused you harm but has no legal basis. So you aren't able to sue person B. So let's look at another one. Injurious side danum. It means a claimant has suffered a legal right, but there is no physical damage. The defendant will be compensated based on the breach of a legal right, but not any physical or emotional damage. So in this case, we are saying person B, has not suffered as a physical harm, but your actions are unlawful. So the person will be compensated because you committed an unlawful act. Like we see even in trespass. Yeah, you're following somebody's property unlawfully. So, as we continue with the law of tort, I want us also to look at other terms. We usually use them interchangeably, especially when we're talking about negligence. So we are saying we are talking about negligence, and because we are professionals, we'll hear us talking about malpractice. So, what is the difference between negligence and malpractice? We find that malpractice is just a professional negligence. Yeah? It is the failure of a professional person to render standard care due to ignorance, negligence, or through criminal intent, especially when injury or loss follows. Misconduct, on the other hand, refers to unacceptable or improper behavior, especially by an employee or professional person. For example, going to work drunk. This is a misconduct. Rape or sexual abuse or harassment of women in the office. This is misconduct. Whereas malpractice is a professional negligence. That means, for example, if a doctor prescribes an overdose more than he should have prescribed, then that's negligence. If a nutritionist prescribes meals without considering the balanced diet, that is a professional negligence. If we tend to practice out of the standard care expected as per our profession, even for a dietetic, then that is professional negligence and we call it a malpractice. Now, on the other hand, misconduct is where we tend to behave improperly in regards to where we work. You might arrive to work drunk, you might cause fight in the workplace, you may be involved in verbal exchange, you may be not dressing properly, and that's professional misconduct. What does the tort of negligence aim at? Tort of negligence aim to compensate the injured and to deter the defendant from such similar actions in the future. And most of the time, the remedy for torts is award of the damages suffered. Elements of negligence. These are the things we must prove in any court of law that existed for us to say there was negligence. We have duty of care, breach of duty of care, causal connection, and actual loss or actual harm suffered or damages. How do we explain duty of care? Duty of care is a legal obligation that is imposed on an individual, requiring adherence to a standard of reasonable care while performing any act that could foreseeably harm others. Let me now use the example of a theatre technician. While during surgery we have swabs and we have instruments, and somehow swabs are usually placed on the patient's body, and as we are suturing back the patient so that they can, can say the surgery is complete, we are usually supposed to remove all the swabs or any other foreign material that could remain in the person's body, including even the instruments we are using. And that's why the swab count is usually done and confirmation of all the instruments which are used. Now, if this procedure is poorly done and we suture a patient with all these things inside them, then we would say that the theatre tech and the entire medical team in the theatre failed to exercise standard of care expected of them, which would have been otherwise performed by any other theatre team. And therefore, we are saying that there was a duty of care. And if that happens, there was breach of that duty of care. So, therefore, we are going to the next term, which is breach of duty of care. Breach of duty of care occurs when a person's conduct fails to meet an applicable standard of care by law. If you are a medic, you are expected to give the correct dosage of the drug. If you are a nutritionist, you are expected to give a planned diet which will improve patient's health. Yeah. If it was a weight loss program, then you have to give a diet that will put them in the correct weight and also nurture their nutritional status so that they don't suffer maybe extreme loss of micronutrients. And so this is, if that happens, then we might be accused of breach of duty of care. What is causal connection? Causation requires a claimant to show that the defendant's breach of duty was the cause of the plaintiff's injury and losses. Yeah. When we breach a duty and we are sued, the claimant has to also prove that because of breach of the duty that we own, that would have caused their problem or the injury. For example, somebody will say, I went for a weight loss program, but I ended up becoming severely malnourished. And I was working with the dietitian so and so. So, was the dietitian's advice the cause of the extreme weight loss, or the client did not practice what was recommended? Those are some of the questions, because there has to be causal connection between breach of duty and the cause of harm. Yeah. So damages, these are the harm suffered or the injury suffered. Damages, similar word can be used, harm has been suffered or injury has been suffered. So this refers to the actual harm suffered by the claimant, because the plaintiff suffered injury or loss which a reasonable person in that same situation could expect or foresee, including monetary compensation. So the damages people suffer out of tortious acts could be physical damages, consequential economic loss, or pure economic loss. Yeah. Other damages may include, medical care which is incurred due to the action, loss of wages, like loss of work, emotional turmoil, or compensation for loss of life. What are some of the defenses which are available in a negligence suit? One, you may defend yourself. The defendant may say, I exercised reasonable care that any other person in my profession would have exercised. Recently, we saw the issue that came up about the child who a hawk jumble logged in his head and was taken to Kenyatta and spent an entire night and day waiting for care. And the mother, according to the mother, the doctors took too long to respond. And in the response, Kenyatta National Hospital, doctors, they said that the case was complicated and still needed, the patient to have enough blood and also needed a lot of consultation. This means that they were trying to exercise reasonable care. Number two, the second defense would be the defendant would say, the negligent act did not cause the plaintiff's damages. Like there was no causal connection between the negligence and the damages suffered. Number three, a defendant may also say he or she did not owe a lawful duty to the claimant. So in this case, the damage has been suffered, but there was nothing legally binding for the person A to prevent such damages. Yeah. Lastly, there are many doctrines that one would adopt to argue their defense that may help them eliminate liability based on the alleged negligence. Such doctrines include the doctrine of contributory negligence, the doctrine of comparative fault, the doctrine of assumption of risk, the doctrine of voluntary non-fit injury, and lastly, the doctrine of exclusion clauses. So let's look at them. What is contributory negligence? Contributory negligence occurs if the claimant is partly responsible for his own injuries. The defendant can plead the defense of contributory negligence. The court may then reduce any damages it awards to the claimant depending on the degree to which he is judged responsible for his loss. The onus is on the defendant to show the claimant was at fault and therefore contributed to their own injury. This is where we say, yes, I committed a negligent act, but also the claimant contributed to the negligence. Maybe not adequate information was provided. Number 2, we have comparative negligence. So the doctrine of comparative negligence reduces a plaintiff's recovery by the percentage in which the plaintiff is at fault for his or her damages. We have pure, modified, and slight gross types of comparative negligence. So in pure comparative negligence, the plaintiff is awarded a percentage of the damages for which defendant is responsible. Modified, plaintiff is awarded damages only if his or her negligence is equal to or less than the defendant's negligence. Slight gross, the plaintiff is awarded damages only if his or her negligence is considered slight and the defendant's negligence is considered gross. Then let's look at assumption of risk. When a plaintiff assumes the risk involved in an obviously dangerous activity but proceeds to engage in the activity anyway, he or she may not be able to recover damages for injuries. Let's take an example of an amusement park. A ride that flips passengers completely upside down. A passenger was on the ride and knew what would happen on the ride, assumed the risk associated with the ride. Voluntary non-fit injury. This applies where the claimant has freely consented to the negligent act. It amounts to an agreement by the claimant to exempt the defendant from a duty of care that he would otherwise owe. Consent can be given expressly where the claimant agrees to the risk of injury or may be implied from the claimant's conduct. Consent acts as a complete defense and no damages will be awarded if it is shown to apply. And this is the case where we use in the hospitals, where patients would first sign a consent form for procedures that are very risky. So after having informed the patient of the risks involved in the procedure and they otherwise agree to proceed, then they will not be suing in case such a risk occurs. The last one, the last defense is exclusion clauses. So an exclusion clause is one which seeks to exclude or limit liability for negligence. If an exclusion clause is found to be valid, this constitutes a viable defense against any action for negligence. In addition, liability is excluded if it is possible to say that the act occurred in the course of nature, that it was an act of God, something beyond human foresight, which the defendant will not have been expected to provide against. Yeah. For example, if in a mine, yeah, you have employees who go into the mine for you, and the walls collapse, like it usually collapse, and the family of the deceased sue you for not having put enough protection for their kin as they were working. But you had put reasonable measures in control. However, the events that happened were out of your control. Then we could say this was an act of God. So I want us to look at what kind of examples of negligence do we experience in the operating room? Yeah. During operation procedures and after. Patients usually complain of one or two. I personally have a female friend who went for a CS section and a swab was left inside her womb in the process of suturing, which developed wound, and she had to go a second surgery to correct the mistake. This was negligence. Some patients suffer consequences of procedures. These may include deep vein thrombosis, post-operation infection, blood clots, burns from cauterization, open wounds or scarring, hypertension, hypothermia, birth injuries, which may worsen. We may have coma and death of a patient, anesthesia and negligence, leaving a foreign object in the body, surgery on a wrong patient, surgical procedures on the wrong sides of body parts. So, the post-operation infections may occur when instruments are not well sterilized or operating room are not clean, and this is the work of a dietetic. Introducing bacteria into the operating room or into the patient's body is negligent and can put that person at risk for potential life-threatening infection. Under anesthesia negligence, if a patient is given too much anesthesia, he or she would suffer oxygen deprivation or brain damage, and in some cases the patient may never wake up. Also, not giving a patient enough anesthesia is also a problem since the patient may wake up in the middle of a surgical procedure. So, correct measures are very important. Foreign objects should never be left inside of a patient's body. So unfortunately, in operating room, negligence items like surgical instruments and swabs have not to be left inside a patient's body, and I'm repeating, it is wrong. As a dietetic, you need to be very careful of such scenarios. Surgery done on the wrong patient. So cases have been reported even here in Kenya where an eye surgery patient ended up with a craniotomy. This was outstandingly bad. Not only does it not address one person's critical medical needs, it needlessly endangers and harms another person. It can lead to lifelong complications, pain, suffering, and other issues associated with unnecessary surgical procedure. It can also delay critical medical care to the person who should have received the procedure. So, what about nutrition and dietetics? What are some of the acts of negligence? So malpractice, and we have defined malpractice as professional negligence, is today's sword of Damocles, threatening not only physicians but the entire healthcare community. The recent increase in lawsuits against healthcare personnel makes it advisable that dietitians recognize the potential for legal liability as they practice their profession. For us as dietitians and nutritionists, there are a number of areas which could be sources of litigation involving negligence or lack of competency. So the questions that we need to ask ourselves is that, is the right therapeutic diet served to the right patient at the right time? Have we done proper meal management plan for a patient for their condition? Always have records when you are giving people care in nutrition. Documentation is important as it will also back up your cases in courts. So some of the common things that we do which are wrong, is pretending to practice or do what is not within our scope. So we must only do what is within our mandate. And then also we are relying on old-fashioned information. And as nutrition is an evolving field, let us try to keep up to date with emerging issues, including correct supplementations, and so on. What are our main sources of negligence? What we call malpractices. Let's try to practice appropriate standard of care when dealing with all patients. Let's be thorough and hygienic in our practice. Practice proper documentation, both manual and in soft. Practice confidentiality and have current and up-to-date knowledge. Let's begin about weight loss, chronically ill patients, patients who are going bariatric surgery, and also patients of malnutrition. So we all know, and we have been covering, that each malpractice case will be covered individually. And there are certain guidelines that we talked about elements of negligence. The elements of negligence would govern or guide a court's decision. A patient seeking legal redress must prove actual injury, a relationship of duty between the parties, breach of that duty, and a cause and effect relationship between the breach of duty and the injury suffered. So in a case of malpractice, the court will look closely at the law on the scope of practice, asking questions about whether the dietitian had the legal authority to provide care and whether the appropriate standard of care was followed. Negligence then would be the failure to act in a reasonable and prudent manner as a dietitian. So when you are committing malpractice, which is the failure of a person with specialized education and training to act in a reasonable and prudent manner, so for the claimant to prove negligence of malpractice, it is important to establish that the dietitian owed the patient or client a special duty based on a dietitian-patient relationship. The dietitian breached this duty and the patient suffered actual harm or damage, and there was proximate cause between the breach of standard of care and the patient's injury. I want to give you an assignment. Write an essay on examples of cases of negligence involving medical personnel. And lastly, I want to give you revision questions. Number 1, outline common crimes against the following groups of people: children, women, and special groups. Number 2, explain the meaning of the phrase damnums and injuria, giving examples. Number 3, outline 4 types of crime commonly committed against children. Number 4, highlight 10 members who compose the Judicial Service Commission. And the last one, illustrate hierarchy of the courts in Kenya. Remember that these questions is focusing on what we have covered from the first class until now. I have encouraged us to use the WhatsApp that we have for chats on the questions and the answers to the questions. For example, as I post this today, I'm expecting that we are going to start even discussing these revision questions on the WhatsApp wall. This will also help us to internalize some of these things. In case anybody has a question on the recording, please let's discuss on the wall. And I'm reminding those who have not completed the last cut, we are facing the second cut, which is going to be online. Please submit cut 1 so that we can mark once and return. Thank you so much.